I'm Jennifer Novak. I'm an environmental lawyer in the Los Angeles area, and over the course of 25 years, I've represented government agencies, environmental nonprofits, private property owners, and all types of businesses on issues involving soil and groundwater contamination, stormwater, endangered species, air quality, land use, and pretty much everything to do with California's natural resources. One question that comes up when I'm talking to non-environmental lawyers is whether they could recover attorney's fees if they either bring or have to defend against a lawsuit. So today, I wanted to go through 5 questions to ask before assuming that you can get back the cost of hiring a lawyer. So question 1, what does the statute say? Now, ordinarily, if you sue someone or you're sued, you don't automatically get back the true costs involved in that lawsuit. But because environmental issues are important, and both the federal and California governments want to encourage compliance with environmental laws, some statutes will provide a mechanism to recover attorney's fees for prevailing parties. Depending on the statute, it might be automatic or it might be within the discretion of the court. Now, question 2, what's the benefit of your win? Does the lawsuit primarily protect your personal or financial interest, or does the cost of bringing the lawsuit outweigh any benefit you're going to receive? Because that's going to matter when a court looks to whether the public has benefited enough to warrant you getting your attorney's fees. Now, question 3, was your win substantial? In any situation, the court is going to look to whether a party is a substantially prevailing party. This doesn't mean you have to win everything, but it does mean that you achieved your primary goals enough to justify the cost of bringing the lawsuit in the first place. Question 4, were there preconditions to how you spent the money? Now, sometimes only certain types of attorney's fees might be recoverable, so you need to know whether your fees qualify. And question 5, were you the plaintiff or the defendant? In cases involving the public interest, the statutes are written to allow the plaintiff enforcing the laws to recover fees, but those same statutes don't provide a similar mechanism for a defendant to recover its costs if it wins. So if you're sued by a concerned citizen and you win, you can only get attorney's fees if you show the lawsuit was frivolous, unreasonable, or without justification. I hope this provides some clarity to the question of why people bring certain environmental lawsuits and not others, and why it's important to be very clear on knowing your options and understanding the true costs of enforcing environmental laws. If you found this video useful, please hit the like button and consider sharing it with anyone else it might help.